Good afternoon, everyone, and welcome to this webinar. Our topic is Privacy in 2022, the year ahead, and we'll be talking about the developments in privacy law that we're looking at this year, where we think things are going. I have a wonderful panel of speakers today, and I'd like to very briefly introduce them before we launch into the discussion. So we have Omer Tene. He's currently at Goodwin and was previously at IPP for many years. We have Maneesha Mithal, and she has recently joined private practice after having spent many, many years at the FTC, where she really distinguished herself in a really remarkable career. And we have Maureen Dry-Wasson, who is the Chief Privacy Officer at Allegis and has been there for quite a long time. So let's begin. I'd like to start just to get your sense of, at first, just a punch list of some of the issues that you think are going to really be the most important this year. And let's start with Maureen.
Thanks, Dan. Thanks for having me here today. I think for when you're in-house and you're trying to keep a privacy program going, each year you sort of start out the year thinking, what's going to be on my big roadmap for this year? And 2022 is kind of an interesting year. We came off of a lot of excitement in 2020 and 2021 and the COVID pandemic, and we have a big milestone 1/1/23 when you've got CPRA going in Virginia and Colorado. So what do you do with 22? You start thinking to yourself. So 22 for us, I think we are watching a couple of big things on our punch list. Quebec recently passed something, and we have major operations in Canada, and we expect the other provinces and then the federal law to follow suit. Obviously, China at the end of last year, and we have operations there. India, sort of, as Dan, you and I talked about, who knows what it will happen, but maybe 2022 will finally be the year. And then all the new U.S. states. We know a whole lot more are going to come on in 23, but you have a lot of interesting legislative activity that's going to happen this year. So interesting to see who else is going to jump on the bandwagon. So we sort of take all of that, and a company that is subject to GDPR like us and CCPA, we've already built sort of the beginnings of a program. We've existed as a privacy team for about 5 years. So the first few years are really about getting in your initial people and some resources. These next few years, as we are adjusting to all these new laws, we are at the same time trying to sort of take the beginning building blocks we started with and do better. So it's not that we don't have anything. We're not starting from a blank sheet of paper, but we could definitely take what we've started and take it to that next notch. So that's a lot for us for 2022.
Dan, unmute. Dan. Dan, we can't hear you.
Okay, sorry about that. I would like to next turn to Maneesha, and I just apologize. I forgot to actually mention the name of your firm. You're at Wilson Sonsini, having just landed there. And anyway, curious what you think the issues are for this year.
Thank you so much, Dan, and thanks for having me here today. So why don't I just start with my maybe top 5 punch list, and we can drill down to them in discussion. So I think number 1 is the potential for FTC privacy rulemaking. I think that's something that we are watching. Second is, I think, greater interest in the intersection between privacy and competition. We've seen that with numerous industry studies that are coming out of the FTC, and a lot of interest in the intersection of both of those areas. Third, I would say, is health privacy. A lot of apps are moving outside the HIPAA area to non-HIPAA covered areas, and I think the FTC is watching that. Fourth is, I would say, fintech. And that's an area that both the CFPB and the FTC are very interested in at the federal level. And the final area I would say is AI. Lots of interest, multiple federal agencies, federal work plan on AI, and that's going to be huge also in Europe as well. So that's my top 5 list, and happy to drill down to any of those.
Omer, your thoughts.
Thank you, Dan. And it is a pleasure to be here. Really appreciate the invitation, and especially with such esteemed colleagues, Maneesha and Maureen. So thank you for that. I think, like Maneesha implied, you can create a punch list for privacy that will just go, throughout this program, and we can sit here for an hour just taking off issues, because the list is really endless and it's constantly growing and evolving. So I'll just kind of name a few. I think the biggest one on my radar these days is global data transfers. Partially just because of the latest decisions coming out of Europe with respect to Google Analytics, which is used by I think a majority of websites worldwide, which just makes it a ubiquitous issue and problem. More generally, I would say international privacy and trying to realign or align the different frameworks. Maureen has already mentioned the new law that's already in force in China. India has submitted a new law, and that, of course, is a major development if it comes through this year. And other countries like Canada, Australia, many others actually are reassessing their frameworks. I'd say enforcement more generally. So Maneesha focused on FTC and FTC rulemaking. But we have definitely seen, I would say almost a hockey stick curve of enforcement in Europe. And I think this is really the year where the rubber hits the road and GDPR enforcement becomes very visible. And then we're talking about law and policy trends, but I think it's also important to mention some of the technological trends. AdTech continues to be a major area of focus for privacy regulators and policymakers around the world. And also some of the, buzzwords which are really coming into focus, the metaverse. Of course, yesterday, Microsoft made its investment of almost $70 billion in the space. And crypto, Web3, blockchain applications becoming much more widespread kind of main market. So those are my top issues, but as I said, it's a very partial list.
So I guess there's really not much to talk about. One interesting thing that's kind of interesting is that, for a while there was discussion of a federal privacy law. No one really mentioned that, and I'm not sure that really we're going to see much. But I think that hope is largely gone for that. But I'd like to I guess start with Maneesha and the FTC. One thing that's really interesting is we have some very different personnel at the FTC. And I think that's going to mean a pretty clear shift into what the FTC is going to be doing and what its strategy is, and how is it going to see privacy, do you think? And what should we expect? Should we expect the FTC to be more aggressive? Do you see different types of cases being brought? Where do you see the FTC heading in privacy?
Yeah, so I think there's no question that the FTC is going to continue to be an aggressive enforcer in this space. But I do think that there's probably 3 main changes over the last year that is going to precipitate a little bit of a change in direction. So I think the first is the one you've mentioned. I think that there is a kind of gap in terms of Congress acting on federal legislation, which is why you've seen so much interest in an FTC federal rulemaking. I think the second piece that's kind of changing the FTC strategy on that is that last year we lost, or I shouldn't say we, the FTC lost a case at the Supreme Court which limited the FTC's ability to get monetary redress for consumers. So if there is a privacy rule at the end of the day, the FTC would be able to get civil penalties and restitution and damages for consumers potentially. So I think those are the two precipitating factors for the new FTC rulemaking. I think a third change, and this is something that's come into play, particularly with Chair Khan's leadership, is her interest in competition issues and the belief that if you break up some of these big companies, if you address some of the competition problems in the marketplace, then privacy will flow naturally from that. And so it's part of the theory in the Facebook competition matter. One of the theories that survived the motion to dismiss earlier last week was the idea that Facebook has bought up all these companies with the idea of stifling competition on privacy. And so I think, these buzzwords, intersection between competition and privacy, I think it's a huge interest for Chair Khan. I think we're going to see a lot of activity in that area. We've already seen, as I mentioned, industry studies on both the competition and consumer protection aspects of social media. We've seen an industry study on the supply chain issues, also having competition and consumer protection issues. So I think that's going to be a trend and a theme going forward.
Well, one quick follow-up. How much do you think that privacy plays in the competition landscape? So is it the big factor? Is it more of a secondary factor? Kind of where does that fit in terms of how the FTC might look at the issue of competition?
Yeah, sure. I think that traditionally competition law is focused on kind of making sure that products are available widely to consumers at the lowest prices possible. And so I think you've heard the FTC in the past say that privacy can be a non-price aspect of competition, but I think you're seeing that with cases like Facebook. And I think there's a number of intersections that go the other way as well. I think number one, there's an interest in seeing more competition on privacy issues. Number two, there's an interest, particularly in our privacy cases, in having competition remedies come to bear on that. So for example, last year, the FTC brought a case against a facial recognition company, or a company that was using facial recognition. And one of the remedies in that order was not only did the company have to delete the data that they got as a result of unfair or deceptive practices, but they actually had to delete the algorithms underlying that data, with the idea being that they should not be gaining a competitive advantage in the marketplace from their unfair or deceptive privacy practices. And so you see a lot of these through lines and intersections on both sides. And I think you'll see more of that going forward.
Dan, can I ask a quick follow-up question?
Absolutely.
Maneesha had a DPIP at the FTC, the division that was in charge of privacy, identity protection, and you yourself wrote a paper about the common law of FTC enforcement actions. I wonder what both of you think about the prospect of rulemaking in this space, how it pans out, because we know that, aside from the statutory rulemaking powers under COPPA, FICRA, some of the specific laws that the FTC is in charge of, Section 5 rulemaking, the MAG-MOS process is very complex, a lot of stages, a lot of opportunities to challenge. Jessica Rich has actually pointed out the prospect of litigation around it. So how do both of you see that playing out?
Yeah, maybe I can start. I think there's really two main challenges associated with the rulemaking. One is it's quite a high legal standard. The FTC has to show that the practices are unfair or deceptive. So you have to meet the criteria for those hurdles, but also they have to show the practice is prevalent in the marketplace. That's a pretty high standard. The other thing is that, for APA rules, the judicial review standard is arbitrary and capricious. The court has to uphold the rule unless it was arbitrary or capricious. For MAG-MOS rulemaking, the standard is substantial evidence. So the judge can overturn a rule if there is not substantial evidence to support it. And I think those create some real legal challenges for the MAGMOS rulemaking. I think the second challenge is kind of timing. There have been articles written about how, the many hurdles in the FTC MAGMOS rulemaking leads those rulemakings to take over 5 years. And we are 1 year into the Biden administration. And so I think the FTC is going to have to kind of speed up in terms of undertaking this rulemaking in order to be able to get something done in a timely manner.
I think that, the FTC, without rulemaking, has been very effective in using a common law style way of developing a jurisprudence. I think it's really built a lot of things. If you look at the body of case law, it's built a lot of rules that could be abstracted from that law that cover a lot if they're studied. I think a rule could be a very effective tool, especially, I think, even more so, stronger enforcement tools. The FTC has cleverly leveraged the limited powers that it has to issue or force these 20-year consent decrees, which companies find particularly odious, and they're a bit afraid of, even though they lack the ability to issue a fine without first getting a consent decree and then having that violated at a second time. So under Section 5, the FTC has kind of tried to come up with a way to enforce but still, I think there could be more. I think it would be very easy to establish that, there's a prevalence in the market for unfair and deceptive trade practices because it's all over the place. We have the FTC is going after a fraction of the violators right now. And so I think that I'd be surprised if you can't make that showing. I think the really tough thing is going to be that the judiciary is particularly skeptical of the administrative state these days. And so I think we're seeing, despite the law being so-called deferential, a lot of courts aren't deferential anymore. And so I wonder, given the climate out there, if this is a difficult time and climate with the judiciary as it is to try to push forward, a rule that's going to be, more aggressive. So I think a rule could be useful. The other concern I have is that, if a rule, sort of balancing specificity in a rule with, too much vagueness. If the rule gets too specific, then there's a lot of things that don't quite fit into the rule. And then companies say, well, you can't do it because it's not listed. We did everything in the rule. You don't want the rule to become, a narrow checklist. On the other hand, if the rule doesn't do much more than just restate, the very broad law, is it really adding something? So kind of how to create the rule, but also one of the beauties of the current FTC approach is its open-ended nature, that it can evolve, it can develop, it can add new things over time. It's not hemmed in by, a particular rule at this particular point, and then down the road there's a new practice that's problematic and it doesn't quite fit into the rule. The FTC can evolve the way it's doing now. So I hope it comes up with an approach that will balance all that. So I'd like to talk to you, Maureen, on your perspective and the things that you're looking at. You're in-house and are grappling with a lot of these new laws that are coming out. In particular, you mentioned China and now the new law in Quebec. And of course, California. So I'm curious your thoughts on, what about those laws are most challenging, and have you most focused on?
So I think we've tried to approach all of those laws and the ones that came before them and the ones that will come after them in the same way, which is you got to get down to the fundamentals and the principles, because if you just try to, I'm going to deal with just California, that just doesn't work, not in an organization our size or any size. So what you say is, well, what do they all have in common? They have certain things in common. I need to have a really good grip on my personal data, what I collect and what I do with it. So that always gets back to the fundamentals of building a good data map. So one of the things I'm doing this year is I'm building Data Map 2.0. So I built one. I don't love it. I think it could be improved. So one of the things we're doing is building a better data map to continue to really understand our own data practices. Omer mentioned earlier transfer issues. We have lots of transfer issues. We're a global company headquartered in the United States with operations everywhere. We have a shared service center in the Philippines. We have a data center here in the United States. We need to be able to move data around. So really understanding that flow of data and mapping that out, and then figuring out how we deal with the transfer requirements, whether that's Europe, whether that's China. That's a big part of what we'll be doing in 2022. So transfer impact assessments, doing a lot of transfer impact assessments to really understand that data. And honestly, once you've done that, then when the next country wants to come on board, a lot of the infrastructure that you need is already built for you to then just go deal with a different cross-border. But the process is very much there. And so I think we focus on sort of those processes. Consent and preference management is a big initiative for us. So nearly all of these laws have some kind of underpinning of needing to capture consent and give people choice. So having much more sophisticated systems that are enterprise-wide, that tie together your various separate systems across your operating companies is a big initiative I started many years ago, and it's finally kind of coming to fruition in 22. As we put in an enterprise-wide system and really study how we're doing that. Data subject rights, they're going to differ by jurisdiction, but having a solid platform, we have one, we could do better. So some of that is you get technology and you sort of turn it on and start using it. And then you realize you could have probably been a little smarter about how you were using it, but you're a year or so in. So we're trying to really stop the world and look at, hey, are we getting good data out of this system? Are the dashboards we developed really telling us what we need to know about what kinds of requests are coming in and what kinds of resources I need to handle them as the requests might scale? So we're really looking at things like that. One example is we right around tax time, we get a ton of requests to the data subject portal for, can I get a copy of my W-2? That's not an access request, but it comes in through the access request portal and tends to really jack up our data numbers. So little things like that, figuring out how we make sure people are using the system the way they should, and we're capturing the data to know that is actually not an access request. So we don't think that we're getting more access requests than we really are. We're also partnering a lot with, we are lucky in the company that we have a really robust third-party risk management team. For us, I would say most of our risks over time have more come from third parties than they come from us. And so really doing good due diligence on your third parties and understanding what they're doing with your data is super important. And so we are really dedicating more resources to the partnership between privacy and the third-party risk management team to do in-depth analysis about the data at the front end and to be a partner all along the path, up through and including the data protection language that needs to go into the contract with that third party. So we're really putting dedicated resources into that field, and we're really ratcheting that up in 2022. And I'd probably say finally, data minimization is probably my other big ticket. With California coming in 2023 to say you can't keep data for longer than is necessary. Like many companies, we have some data hoarding problems, and we have a lot of data and a lot of legacy systems, structured data, unstructured data. So there's a very large project at the company to get a better handle on how we better store, manage, and delete that whole data lifecycle, our data.
So, Omer, I'd like to start. Can you mute Maureen, please? I would like to talk about one of the issues to start with that you mentioned, cross-border data transfer. With the latest decision out there, it's looking like it's going to be really complicated. And I'm curious your thoughts on where do you think things are going?
Yeah, thanks, Dan. I mean, it has looked like it's very complicated for a while. Now it actually looks like the window of opportunity is shutting on finding practical or even creative solutions to the problem, specifically of transferring data from Europe to the US. You know, the Schrems 2 case obviously cast a cloud over the continuation of data transfers, not just by invalidating the privacy shield, but also by posing serious questions about the validity of the standard clauses. I think people kind of stayed the course and put in place standard clauses, if only because they didn't see many other options. But now with these decisions, first, the EDPS decision with respect to the European Parliament's use actually of Google Analytics and Stripe cookies, and then the Austrian DPA's decision with respect to a website's use of Google Analytics, that window of opportunity, I think, is shutting, because it's one thing if websites can't use Google Analytics. It's, you know, an incredibly widespread tool that really everybody is using. But, you know, the world, I guess, can continue without it if that's what people think would solve the problem. But it's more than that, because the Austrian authority basically held that the mechanisms put in place by Google, which were signing standard contractual clauses, having transparency reports about government access, and by the way, specifying that they have never received a government request for this type of data, putting in place the identification so customers of Google Analytics can truncate IP addresses that go through the system, encryption of data in transit and encryption of data in rest. If all that is insufficient to satisfy the concerns that the European regulator has about the possibility of government access in the United States, then, you know, it's difficult to see what would suffice. Now, I guess one can say that Google is a FISA company, quote unquote. It's subject to potentially more intrusive or greater interest from national security authorities, true. But my point about the insufficiency of standard clauses plus supplementary measures, I think, has broader reach. And, you know, mind you, this isn't just a US problem. The EDPB just released a report on government access in China, India, and Russia. And of course, you know, they haven't yet released reports, but we kind of know the situation in other countries around the world. And it's reciprocal also, because I think Maureen mentioned the troubles with data transfers from China. It has, you know, a partial localization requirements for certain types of data and controllers, and otherwise data transfer restrictions. And the Indian draft also has localization requirements. So I think where all that puts us is in the context of EU-US, the only practical solution at this point seems to be a government brokered one. And, you know, hopefully the two parties can reach a new privacy shield. And then on the global level, perhaps some international convention or agreement. The OECD is working on something to kind of help these systems become more interoperable, because, you know, the data flows are continuing and are, it's an understatement to say that they're widespread.
So one thing that's kind of interesting about this latest decision with Google Analytics is it's not just like, you know, a company transferring its employee data or Facebook transferring all this data about its users. This is just basic analytic data about web surfing. And so does that mean that, you know, I guess, how does the internet work if we don't have a deal? How does this work if every country starts saying, hey, any kind of analytics that is going on your website, which is, pretty much most sites, can't be transferred? I don't quite, I just wonder, what are the implications just for the functioning internet? Like, how does this work?
Absolutely, Dan. This isn't a case about tracking or profiling third-party cookies. This is about audience measurement and analytics. It's like, as you say, it's the life and blood of the internet. I think if you read the case, and I have to, put in a disclaimer because I read a ironically machine translated Google Translate version of the decision. I don't read German, but if you read it, you see that the Austrian DPA is basically assuming, without, if I could understand it, much evidence, that Google or the US government can use these tools and these data points to pinpoint, to identify, to single out individuals. I don't think it's been proven. Maybe it can be, but in any case, as you say, this is how the internet was kind of built, and its architecture and the way it works. So if it's illegal, we have a problem, Houston or Brussels.
Does anyone have any thoughts on the cross-border issue? Anyone else want to chime in on this?
I mean, I certainly agree, and it's frightening, the decision. I think for companies, we don't have any choice but to keep the lights on and keep doing business. So if the regulators really are moving in directions where business just can't be done, it's going to create issues. But I just don't know that any businesses are going to stop. If we can help it. We're trying to do the best we can, but I agree with you, Omer. I mean, I think all of us were building exactly what the Austrian DPA now said isn't good enough, right? That's what we just finished building. So that's a little depressing because you're like, okay, well, that's just what I finished putting together, was thinking through all my supplementary measures and thinking about the type of data, which that isn't even really a data set I should think anybody would care about, thinking about whether we've actually gotten any requests, doing FISA analysis. Now, obviously, we aren't a FISA company, but the numbers of FISA-based companies, are they just not going to be able to do business? Transatlantic, that just doesn't seem feasible. I mean, again, most of the world relies on AWS, so I can't even imagine how that's really going to be feasible. And so many of us need support functions where a transfer has happened from all these countries in Europe to various places in APAC. India and the Philippines are both big areas where companies have support services. And then obviously the US. It'd be very difficult for a global company to keep doing business. So we obviously hope for Privacy Shield, but honestly, that only solves for the US. That doesn't help us with India or Singapore, who have GDPR-like laws. India is at least striving for it. Singapore already has it, but they haven't been declared adequate. And that whole process will take longer than we have time to wait. So yeah, it really creates some interesting consternations. But I think for companies, we continue to just do the best we can. Secretly, I think we all are glad we're not Google because they can't just do it. They can't do anything right. No matter what they do, they get attacked. And the rest of us are just glad we don't get that level of scrutiny, and we keep doing the best we can.
Maneesha, do you have anything?
I don't have much to add to what Omer and Maureen said. I think, just from the kind of FTC perspective, I think, earlier on, the last time around with the Privacy Shield negotiations, the FTC was quite active, and you had a lot of statements by then Chairwoman Ramirez. I think now the FTC is noticeably more quiet. I think this is really viewed as kind of a business issue more than a consumer privacy issue. So I think that probably explains why. Dan, I see a question in the chat. Do you want us to answer those, or?
If you see a question that you'd love to address, then please, by all means.
Yeah. So it looks like Mike has asked how comprehensive the FTC rulemaking is likely to be. All we know from the notice of rulemaking is that it's going to cover privacy, security, and algorithms, which seems pretty comprehensive to me. I think the challenge here, in light of our previous discussion, is it's almost a lot easier to do a narrower rulemaking and get it done in time and kind of have fewer issues. So the first MAGMOS rulemaking that the FTC put out in December was on impersonation fraud. That seems like a narrow, simple issue. It was, bipartisan consensus on that. I think, this advanced notice of proposed rulemaking, if it includes all these three issues, I think it's going to be pretty comprehensive, and it's going to be a real challenge to get it done in the time frame that it has to be done in.
And do you have any hopes that, one is for Congress to sort of pass a more, an actual comprehensive privacy law, which I don't think is in the cards. But there were thoughts of, giving the FTC, punting to the FTC, giving the FTC a lot more money, giving the FTC a lot more rulemaking authority. Does that also look dead? I believe there was something in the Build Back Better Act, but is anything still alive there, or you think that's probably?
I think if not dead, maybe comatose.
Okay.
I think there's always some hope that Congress will be able to do something, maybe even kind of reverse the AMG decision, or kind of do something about FTC authority or even appropriations. And I think the idea at the FTC is, people are hoping that will happen, but nobody's holding their breath, and they're continuing on the several fronts that they have been. So, trying to put their eggs in different baskets.
I think then, putting the resource allocation issue aside, if Congress did just pass the provision empowering the FTC to impose sanctions on the first strike, it would be hugely impactful for our field and for the agency's ability to function effectively in this space. And it's a long time coming. So I know this was part of the budgetary appropriations bill, which kind of got stuck, but hopefully at least that can move forward, short of like the grand, federal privacy law, which I don't think we should hold our breath for.
So an issue that you had mentioned also, Omer, is enforcement. And your prediction is that we're going to see some real heft to enforcement. I think that, if we look at enforcement in the EU thus far, we definitely see there are fines. Although what's interesting too is that there's the reported fines, but actually then on the back end later, when no one's paying attention, these fines are reduced to dimes on the dollar. So you really, if enforcement, it's there, but there's been a lot of criticism of Ireland, and that they're not enforcing strongly enough. They obviously have, I think, a disproportionate share of the cases. I wonder what's on the horizon. Do you see a real change there in enforcement? Do you think they're really going to start catching up? And how about around the world? Definitely see China starting to get very, very, very quick out of the gate enforcing.
Yeah, so just start with the EU. I don't think you need to crystal ball this at this point. It's happening. We were talking about the Austrian case, and that was the first out of 101 similar complaints that Max Schrems' organization, NOIB, filed with respect to different companies. And I think, based on what the Dutch DPA already said last week, we can expect to see this wave, this tsunami hitting shore imminently. I'm pretty confident that will happen. So we'll see a lot more of that. Of course, just a few weeks ago, the CNIL issued a fine of more than 200 million euros, I think, total, against Google and Facebook in a cookie context. last year, the Luxembourg DPA reportedly issued an intent to fine Amazon almost $1 billion. I take your point about the later reductions. I think you're pointing to the ICO fine specifically against, I can't even remember who it was, like a couple of household names. I think the Marriott even. Which was later reduced, but I think that was tied to the pandemic. With respect to the Ireland DPA, I think it's been very active already. There are a lot of enforcement actions coming out of Ireland, not only in the big sort of multinational cases, but also in important domestic cases. And, some of these cases are incredibly complex, and specifically for the Irish DPA as the one-stop shop, touch on, sometimes all 27 European member states. So they have to go through the consistency and cooperation mechanism, Article 60, and then the Article 65 sort of arbitration decision-making process. So it takes time. And, Ireland is a common law country, which it has an adversarial process, and parties get to submit their positions. And in fact, Facebook, for example, has already pushed back and appealed a couple of interim decisions with respect to WhatsApp, and I think maybe Facebook itself. So I think where all that lands is that it's not much of a prediction. I think it's a reality that we will see a tremendous wave of enforcement this year in Europe. And, with respect to China, that too isn't much of a question mark, I think. The Chinese regulator isn't new, it's well established, the cyberspace administration. China, it used to be just a cyber security regulator. Now it's also in charge of the PIPL, and it's been very active on the enforcement front, specifically with respect to large Chinese, so domestic tech platforms. And I have no doubt that the CAC will continue to operate in this space.
So, Maneesha, you had mentioned AI as an issue to watch, and we haven't spoken much about that. And I'm curious your thoughts on, where you see that going, where you see the regulation heading. Are there, what efforts look like both abroad and here in the U.S.?
Sure. So I think just from the U.S. perspective, there is a lot. There is a law where many arms of federal government are supporting research, doing research on AI. NIST is doing a project to assess risks on AI. In terms of the FTC, they put out guidance last year telling companies that if you're a seller of AI or you're kind of a business consumer of AI, you need to watch out for several things. If the AI is used in such a way that has a discriminatory outcome against a protected class, that could be an unfair practice. There have been earlier warnings that if AI is used to deny people housing or credit or employment, that could be actionable under the Fair Credit Reporting Act. So I think a lot of interest in this, a lot of interest in looking at tech companies that are offering AI solutions, what kinds of claims they're making, can they substantiate their claims? So just a lot of interest in those kinds of issues. And I think where the interest stems from is, I think the FTC's recently expressed interest in racial equity and justice issues. And so I think that's what's driving a lot of this interest. And so a rejuvenation of statutes like the Equal Credit Opportunity Act. And so I think the big question here is, if you're serving ads for subprime products to particular racial minorities, whereas you're serving ads for good credit to affluent white men, is there some sort of unfairness theory that the FTC could come up with? And so I think that's something that the FTC is looking at. I think it impacts ad tech, fintech, a number of marketplaces. And so I think that's absolutely an issue to watch in the coming months. I did want to go back to one thing that Maureen said. It was interesting as she was kind of talking about the issues that she's focused on, things like data minimization and vendor management and kind of the choice interfaces, I was just reminded that, since 2009 at the FTC, we've probably settled 100 cases or so in these areas. And I would say like 80% of those cases had something to do with one of those: lack of oversight of vendors, lack of review of consumer interfaces, or lack of data minimization. And so I think, despite, all these new laws, I think Maureen characterized it as a 2.0 review. But it's very interesting to see that these are the issues that have been kind of evergreen in regulators' minds. And it's great to see that people are redoubling their efforts on that.
And if I can jump in, to Maneesha's point now, I would say that this in a way proves the effectiveness of the FTC. You called it then common law. I know it's contentious. I won't call it that, but say body work of enforcement actions, because as Maneesha said, it has very good guidelines, short of formal rulemaking, for things like data minimization, vendor management, security, of course, and others. With respect to AI, Maneesha talked about the US federal situation and mentioned the AI reg in Europe. I would just add that China too is actually a torchbearer, a leader on AI regulation. And New Year's Eve, a couple of weeks ago, it set forth new regulations about AI, automated decision-making, and recommendation algorithms. So that's important to look at. It's much more granular than some of the principle-based rules that we see in the US and Europe. And then also mention the US states, which in addition to laws about privacy have also been innovating on regulation of automated decision making.
So a question for you, Maureen, on this topic. I don't know how much AI your company uses, but I'm curious, just from an in-house point of view, in an area where the law is so young, and there's so many directions it can go. We really see that's brewing, bubbling up in the law around the world. How do you think about an issue like this, and how to proactively deal with it? Is it sort of wait and kind of just keep an eye on the regulation? Are there things you do to get ahead of it with internal types of guidance on what might be done for AI? I'm wondering just kind of how you think about what you would recommend for governing this until the law gets to where it gets more mature.
Yeah, it's a tricky question. So I totally agree with everything that Maneesha and Omer and you have said. AI is a huge issue for us. Probably should have made my original list, I'm sure. For us, really in the recruiting space, because I think for any large employer, and given that our whole business is employing people, the volume of data that comes in about people, the resumes off of job boards, the ability to parse through that data in any meaningful way to quickly try to match jobs with people, which is basically what we do, and is what any employer is trying to do, but we're trying to do it sort of at a escalated level, given that we're in the staffing business. That is not an easy thing to do without AI. It almost has to be done with AI. And it's this very difficult conundrum, because we understand that the sort of fear that people have about AI and the bias that might be in AI in the job context. There's bias in human beings who review job data, of course. And the question is, how do you get AI to the right level that people feel better about it? So we're certainly getting involved in a lot of groups focused mostly on the recruiting issues specifically. Other very large employers wanting to team up with anybody from academics to others to really study it, because we really do think it's a crucial problem for really everyone to solve around the world. It isn't going to be feasible to not have it. What we have to figure out is, how do we make it responsible, and how do we do it in a way that is right? I think companies want to do it right, But as to your point, Dan, we're out there innovating because that's what we need to be doing. And we're always feeling like we're probably ahead of where the law is helping us figure out where we should be. So it's a constant source of tension.
I think one of the interesting developments with regard to this is that, the AI issues involve more than just privacy, which could be, just finding out, making inferences about people and getting data to feed into the algorithms. But there are other issues such as, the fairness of the decisions, the discriminatory implications of these decisions, which are not necessarily directly privacy issues. But I don't see any other, other officials and companies addressing them other than the privacy officer. And I think that generally when you look at, kind of where I think in the law, I think you're seeing regulation in different places, but privacy is a definite source of a lot of it. So it seems to me that, privacy is going to be the place to address some of these larger, broader social issues when it comes to, algorithmic decision making. I'm wondering if there are other sources and how that would coordinate or how it's going to work, or is it going to become kind of like a subsumed into privacy?
I mean, the EEOC has been weighing in heavily in this area as well. Part of the problem is just the regulations that are around are so antiquated. They so predate how the world consumes data that whether you're looking at it from a privacy standpoint or employment law standpoint, you've got real problems. The law has just not kept up. They are well back into the days of reviewing things on paper and nothing more. And so what we have to do is to sort of, as I said, I think it's going to take cross-functional teams, people who are in government, people who are in academics, people who are in companies like us who are trying to solve real world day-to-day problems, partnering together to figure out where we take this. I don't know that any one of us can solve it alone. And I think if we do, it won't necessarily be trusted very well if we aren't a bit of checks and balances on each other. But I think that's where it needs to head. And certainly what I think companies, certainly our company and other companies I know are willing to do that. I think what we want is the ability to try to innovate in this area, as I said, because I think that's in the best interest of our company and others, and to continue to move the workforce. We have an awful lot of jobs that need to be filled, and figuring out how we quickly do that and effectively do that is in everybody's best interest.
I like what Maureen said about the cross-disciplinary nature of this. I mean, what's interesting is that the CFPB last month put out a blog post. Their technologists said that they are looking for whistleblowers within organizations to report to the CFPB on kind of unethical use of algorithms. So the CFPB is bringing technologists to bear. Obviously, data scientists, ethicists, and others are going to be involved in this. But I think this also brings to the fore, I think it was Omer who posted it on LinkedIn, this kind of difference between privacy and data protection. And so we call this privacy, but really we're talking about data use and data protection. And so, this is where some of these terms may be a little fuzzy. And but I think, Dan, you're right. I think the privacy folks have been at the forefront of thinking about AI issues.
Yeah, I think one of the sort of overarching themes here is due process, which of course is a constitutional right in this country. And then I remember Daniel Citron's seminal article, I think it's more than a decade ago now, about algorithmic due process, which surfaced a lot of these questions and challenges before, we were thinking about them. So I recommend people look that up. But, now that I have left the IPP, I can reveal that our secret mission was to control the world, world domination. And I'm glad that privacy officers are beginning to own this topic of algorithmic decision-making, due process, fairness, equity, because if you think from an organizational perspective, who would you want to manage, to address, to sort of think large about issues at the intersection of technology, law, ethics, policy, I think privacy officers tick a lot of these boxes. So it's a good development.
I think that's a great note to end. We are nearing the end of the hour, and I know folks have stuff coming up at the top of the hour. So I want to thank all of you for a really fascinating discussion. I think we could go on and on and on about these issues, as well as many other issues that we didn't have time to cover. But thank you so much for joining with me today. And I hope we can continue this conversation. I expect us to continue this conversation in the days and years to come. So thanks a lot. And to everyone, have a good afternoon.
Thank you.
Thanks so much, Dan.
Thank you.